Good morning, everyone. Sorry for the delay. My name is Mark Socher, and I'm Human Resource Counsel at CBIA, and I'll be hosting today's webinar on the topic of background checks, latest trends for 2015. I appreciate everyone's patience. We had a slight technical difficulty in getting everyone signed on. For those of you who might be outside of Connecticut or not familiar with CBIA, we are the state's largest employer association, offering services to member companies in a wide range of areas, including consulting, education on human resource issues, safety and business management issues, representation in Hartford at the state capitol, lobbying public officials to promote a strong business and job growth climate in the state, and we successfully administered a large insurance program, essentially a private exchange, since 1995. I'd like to thank the generous efforts and time and expertise of our speakers today, which makes this program possible, and we are offering it at minimal cost, as I hope everyone is appreciating. We feel that this type of education is extremely valuable for the business community, and that's why we do this. A bit of housekeeping on today's webinar. The format will be a slide presentation on your screen with voiceover commentary from our presenter. We also have the capability of real-time Q&A using the text box on the right-hand side of your screen. The lower box there where it says Q&A is a platform by which attendees may ask any particular questions on the subject matter that we're dealing with as we go through. We'll be monitoring that, and generally what we've found is we are able to respond to questions as they arise during the course of the presentation, but if there's any that we can't address at that moment, I think we'll have time at the end to pick up and address any outstanding questions, or we may delay slightly if it's something that will be addressed later on through the course of the presentation. So please take advantage of that. This can be a much more interactive presentation if questions arise, and I may be posing some questions as well as we go through that. This morning's presentation is being recorded and will be posted on CBIA's website for later viewing by you or others in your organization who you think might benefit from the material, and we'll be sending out an email afterwards to all attendees with a link to the recorded online presentation on CBIA's website. And the presenter's contact information will be posted on the final screen so that anyone wishing to follow up with Al Sparacco and Baker Street Associates can do so later on. Now, on to the presentation today. Al Sparacco is president and founder of Baker Street Associates. Since 1987, he's been providing investigative support and security consulting services to companies throughout the United States. Al's clients include companies and organizations in the fields of pharmaceutical, biomedical research, retail, finance, hotels, advertising, entertainment, education, and manufacturing. Specialty areas of his work include pre-employment background investigations, comprehensive security assessments and audits, loss prevention programs and consultation services, due diligence investigations, and prevention and investigation of computer crime. In the past, Al has served for over 40 years in the investigative and loss prevention field, in particular for an extended period with the Lord & Taylor stores. And Al has just a long list of professional affiliations and certifications and licensing in the security and investigative field. He is a licensed private investigator as well in both Connecticut and New York. He's a part-time instructor at Western Connecticut State University, serves as chairman of the Police Commission in his hometown of Brookfield, Connecticut, and has previously been the chairman of the Southern Connecticut of the preeminent investigative association, ASSIS International, which is a worldwide organization of security professionals with thousands of members worldwide. He brings great expertise, knowledge, and experience to this topic, so I'm going to turn it over to Al now, and we'll start going through the materials. Al?
Thank you, Mark. Good morning, everyone. Thanks for your patience, and we'll begin. So what we're going to talk about today, I'll give you a bit of an overview here, talk a little bit about us, and not too much since Mark already covered most of that. Thank you, Mark. The benefits of conducting employment background investigations. We'll talk about the background screening programs, background search components, criminal checks, myths and facts about such, and legal requirements and implications. So anyway, Mark had mentioned this information here. Was founded in 1987. We won't delay here. We'll get moving into the presentation. So why do you want to conduct a background check? So you want to provide for a more effective workforce, lessen the probability of turnover, increase the efficiency of the training and orientation dollar, ensure that corporate standards and government compliance requirements are met and are maintained, aid in maintaining a safe and secure work environment, ensure the security of physical company assets and intellectual property, and avoid negligent hiring claims. So those are some of the main reasons why you want to consider doing background if you're not doing them already, and if you are, that would support the reason why. Screening programs that fail. Okay, so selective programs, kind of what we call a random approach, and that's where people will decide or choose to say, well, let's do a background on this candidate. We don't have to do one on this candidate. Those are ones that don't really work too well. And then we get occasionally what we call the program, which is a special request. That's when someone has hired an individual and they learn through some other source, someone recognizes the person or the name and says, I think that person's got a criminal record. And they contact us and they want to do a background on that person. They've never done it in the past. And then, of course, no program we think is an accident waiting to happen. If you're not doing any sort of background screening at all, in this day and age, we think that's potentially a mistake. So screening programs that work. So first, you need to determine the level of risk exposure for each job category that you want to do background screening for. And you kind of look at it from the point of view, what information, materials, assets, secrets does that person have access to? And how is that protected? What is the level of supervision of that person? Do they work alone or with others? And who will they come in contact with? Do they come in contact with other employees, the general public, those kinds of things? Those are things you should consider when you're trying to determine the level of risk exposure to the job category. Then you want to decide on what searches can help reduce those risks when hiring. And then, of course, you want to establish a set of acceptable guidelines and standards for screening candidates at all levels. Once you've got that together, then you want to implement and maintain a consistent approach for adjudication of the background screening results. So one of the factors that you have to consider in the use of criminal convictions is the EEOC, Equal Employment Opportunity Commission, as identified in a rule that they issued in 2013, this matrix, if you will, of what you should consider when you want to use a criminal conviction. So number one, they want you to look at the nature and the gravity of the offense or the conduct, the time that has passed since the offense, the conduct, and or the completion of sentence, and then the nature of the job being held or restored. So how does it relate to the job? Some obvious examples, let's say a pharmaceutical firm, if a person's got a drug conviction, you can easily make a relationship with the nature of the job that they're looking at as something that might be an issue. So that's an example there. So what's typically the hiring process? You come up with a job description, you list the requirements of the job, you advertise in some way, either newspapers, through associations, maybe on LinkedIn, and then you have an employment application. Typically, someone may provide you with a resume first, and the difference between the two is an employment application is your business record. You should always have an employment application, and if you don't have one, I believe CBIA might even have some sample forms that you can access as a member. A resume is a candidate's sales tool. It's the way to sell themselves to you. So it may be incomplete. It may not have complete information on it. It's something to consider. So I would always recommend an employment application which has specific questions that you're going to ask that you want details on. There's what's called an FCRA disclosure and consent if you're going to use a third party to conduct a background, such as Baker Street. The Fair Credit Reporting Act governs, and we'll talk about this more in detail later, but it governs the background screening industry. They have an interview process, and you conduct a background check, and then have adjudication, and you move to make the offer, or prior to the offer in some cases. So the typical components, what do you check? One of the typical components that probably 95% of our clients use is what's called a social case, and it's taking the Social Security number and it's traced to a commercial database that's used primarily in the screening industry as a tool to identify current and previous addresses of a candidate so that we can match that up with the disclosure and consent to make sure that we're checking for criminal records in the appropriate jurisdictions. It also, it's not coming from the Social Security Administration directly. It's through this commercial data set. The only component that's part of the Social Security Administration database is what's called the Social Security Master Death File. So periodically that commercial database is updated to include a published record that comes from the Social Security Administration of people that have died and their survivors filed a death claim with the Social Security Administration. So that will tell us, for example, if someone's using a Social Security number that was previously used to file a death claim. So that's what it's good for in that particular regard. So again, it's a small tool that we use, but it's pretty much a standard component. The criminal conviction search, of course, is obvious. You want to check to see if the person has any criminal convictions in whatever jurisdictions they lived at. Typically, the time frame is within the last 7 years. And another component is work history, so verifying a person's work history. Education, the same thing, verifying education. If there's a professional or business reference, if you want to try to look for qualitative information besides just the straight verification, a good source for that. Driving records, if the job requires or entails the driving of a motor vehicle on your behalf, then you want to check your driver's license. Credit reports, again, limited to people that have financial responsibility. There's some guidelines in Connecticut law about when you can use a credit report in connection with an employment application. And again, it typically falls on the side of the person that has financial responsibility or fiduciary responsibility for the company. So they have access to other people's confidential credit, for example, information, credit card information, personal identifiable information. And then professional standing would come into play if a person has some sort of license or certification, and then, of course, drug screening, and it depends on your particular organization whether or not you want to have a drug screen done. There are some industry-specific components. So, for example, the pharmaceutical industry or healthcare, we use what's called a federal debarment search, which covers the FDA, HHS OIG, which is Health and Human Services, Office of Inspector General, and the GSA DPLS, which now, that used to be the excluded parties listing system, it's now called SAM, and it's the Central Repository System Award Management is what SAM stands for. Government is famous for acronyms. It's where all debarments that are done by any federal agency are housed at the Central Repository. So any federal organization, agency for issuing federal contracts has to go there, as well as entities in the private sector who receive any sort of federal funding. So that's a standard search. And then Patriot Act compliance, OFAC, the more common one that's listed in that database in Office of Foreign Access Control, has to do with, as you see here, known individuals, groups, entities such as terrorists, narcotics traffickers that have been sanctioned by a federal governmental agency as a result of their activities. It's got about 135 lists, but the one that primarily we're asked about is OFAC, so it does contain OFAC. Compliant criminal checks. And there's a way to do the correct criminal check is either a direct contact with a government entity which holds the record, and we either do that by means of electronic access, fax, rare occasions, telephone, rare occasions, mostly it's electronic access, or we have researchers that actually conduct physical inspections of the court records, and we do that around the United States. All records that are found by us must be reviewed to ensure that they're complete and up to date, and they're in compliance with federal, state, and local reporting requirements. And that is also a requirement of the Federal Fair Credit Reporting Act that the information is accurate and up to date. So just a little bit about criminal conviction records, what types there are. So we don't have counties in the court system in Connecticut. Most other states, all other states do. They operate in a county court system structure. In Connecticut, we work in judicial districts. So we do statewide criminal searches in Connecticut through the judicial district. Superior court records in other places like that have counties like Massachusetts, New York, New Jersey, They generally have jurisdiction over felonies and misdemeanors in violation of state statutes. Some states split up and have a district or a municipal or magistrate court that has jurisdiction over misdemeanors and traffic violations, and the Superior Court maintains the jurisdiction over felonies. But the state like Massachusetts, both the district courts and the Superior Courts can handle felony cases, and the differences in the district court in Massachusetts, if the felony would render a sentence of 5 years or less for a conviction, then it's handled by the district court. Anything over 5 years goes to the Superior Court. It's kind of a unique setup. In most other states, the split between felony and misdemeanor is what denotes the difference between superior and district or local court. State criminal record repository, that could be a state police organization. For example, Connecticut State Police, you can run a criminal check through the state police. Many other states have the same type of facility. We do it in New York through the New York State Office of Court Administration. That's the record repository that's statewide in the search, but it's actually through the courts instead of through the state police. And this is what's called the U.S. District Court, and that deals with crimes against U.S. code. So, for example, if a person is arrested by a federal government agency, like the FBI, for example, or the IRS, those cases are going to be held in U.S. District Court. They're not going to be held in state court. So if you ran a criminal check and you just limited it to state court, and a person was convicted of a crime involving an arrest by the FBI or the IRS, for example, you're not going to find that when you check the state court records. So, for example, if you have a compliance requirement and it says the person cannot have any felony convictions, and it's a generalized statement like that, then you would be best served to check both the state and the federal courts. Town and village court, again, mostly handles local ordinances or violations in a local matter, local statutes. This Connecticut, I just mentioned before, but there are 15 judicial districts, 22 geographic areas, 14 juveniles. So in general, major criminal cases and civil matters, family cases not involving juveniles, are heard in judicial district court locations. Other civil and criminal matters are heard at geographic area locations. Cases involving juveniles are heard at juvenile court. You can't access juvenile records anyway, so it's just a matter of the way the structure is. FYI. So what's a national criminal check? Some people have heard of that. Some companies offer it on the web. A true national criminal check is not available to the general public unless it's allowed by statute. So, for example, a bank, because of the nature of their business, they have under statute, they're allowed to check national criminal records, and they do it through the American Bankers Association, who acts as the conduit for the record to be submitted to the NCIC database that's managed by the FBI, okay, the National Crime Information Center. And others, like the Regulatory Commission, that have the same type of access. There are a number of different statutory allowances. But in general, the general population, most companies don't have access to that database. So the type of search that could be used as an alternate or a supplement to a regular criminal check would be a national or a multi-jurisdictional criminal search, which is our search, we call it a multi-jurisdictional criminal database. So, and why we call it that is it doesn't cover all jurisdictions in the United States. It covers many. It may not be FCRA compliant, so it may contain inaccurate or incomplete information. So when we run a search in that database and we get a hit, if a client wants to use the multi-jurisdictional as an add-on, we then have to go back to the original source of the information, the governmental entity, and verify that information is accurate, current, and up to date. So as I mentioned, we only use it as an add-on, and we have to verify those sources. So legal considerations for background investigation. So as I mentioned before, the Federal Fair Credit Reporting Act is the guiding principle for conducting background checks. It's not just what you think in terms of this credit only. It covers all components. There are two parts to the law. One is the consumer report, and the other one is the investigative consumer report. So the consumer report is referring to credit reporting, and the investigative consumer report refers to any other component, such as education, employment verification, and such. In addition, there are responsibilities for the employer, which we'll get into in a minute, and there are consumer reporting agency responsibilities. So there is state laws in addition to the Federal Fair Credit Reporting. Some states have enacted their own Fair Credit Reporting Act. In some cases, has additional requirements or restrictions. Connecticut is not one of them, but there are many other states. Neighboring states like New York is. We always, suggest that you consult with legal counsel to ensure compliance with all federal, state, and local laws. And I mentioned before when we talked about EEOC's use of criminal convictions, there are rules you need to follow.
Just, Al, one point on the EEOC standards.
Sure.
I believe that that's not a complete mandate that you can't rely on criminal background information at a certain stage, but what it does is raise the issue that if you have this initial screening step, that anyone with a criminal involvement in some fashion is rejected in terms of going any further with the application process. That statistically is considered to have an adverse impact on minorities, and so it can't be used as a preliminary screening. But ultimately, when you get into the individualized consideration, then you can readily use criminal background information. Mm-hmm. That's correct?
Yes, that's correct. And again, it's important. The EEOC, for maybe as far back as 20 years, has always been against using criminal convictions as a component when you're talking about, determining whether or not you're going to hire somebody. They've been against that from the get-go. And it reached a plateau in 2013, and we'll see a slide later on where a background screening company, a corporate client was fined or agreed on a settlement as a result of that use of that information. And they then took a stand and issued that rulemaking, suggesting that these rules be implemented when you're using criminal convictions. And it's more of an individualized basis. They don't want any kind of blanket treatment, which is what that organization was doing.
And then so long as those three factors with all the details behind them, the nature and gravity of the offense or conduct, the time that's passed since the offense, or completion of a sentence if the person was sentenced to incarceration, and the nature of the job being held or sought in relation to the criminal activity. If those are brought to the analysis, then that's a permissible use even in the eyes of the EEOC. Is that correct?
Correct.
Yeah. Okay.
So some of the employer obligations under the Fair Credit Reporting Act, and again, just to define, if you're using a third party like a Baker Street, any kind of what's considered a consumer reporting agency, and we are by definition of the FCRA, consumer reporting agency, we collect information about consumers and we sell it for a fee. That's the basic, simple definition of it. So any type of company that you're going to get information that they've collected about a consumer, they're a CRA, and they have obligations, and you, as the employer, have the obligations as well. And the obligations
and that would include an online search service as well, correct?
Correct. Absolutely. It doesn't matter where they're located, whether they're bricks and mortar or they're online or both. They're a consumer reporting agency, and some of them will try to, skirt that by saying that they only collect public record information. Somehow they're able to do that in some cases, in other cases not. But you, as the employer, should be aware you could be using an organization that's not compliant with FCRA, and we'll talk about that in a couple slides later. So first of all, you have to have a permissible purpose. And one of the permissible purposes is in connection with employment. That is a permissible purpose for you to obtain a background report on somebody. There are others, something to do with issuing insurance, granting credit, of course, the standard one that you're familiar with. If you all sign any kind of credit card application or loan application, that's a permissible purpose, and you're giving the credit grantor permission to run your credit report, for example. So the next thing that's a requirement for employment is providing a clear and conspicuous written disclosure to the candidate before the report is obtained in a document that consists solely of the disclosure that a consumer report may be obtained and used in making hiring decisions. And that's really important because there have been recent cases where companies that are not following that process are being challenged in court and winding up on the short end of the stick. So it's very important. And it's got to be a separate document. It can't be buried in an application format. If it's an electronic application online, we certainly recommend that there's some kind of line drawn or a distinction between your application questions and this disclosure and consent. So, for example, one of our clients, they've taken our disclosure and consent, which is in compliance with FCRA, and with our letterhead logo on it, and they've inserted that into the mix of their paperwork online as the last thing the candidate sees, but to them it's identifiable as a totally separate document. logo appears on the top of it, and it clearly says FCRA disclosure and consent.
And an advisable practice might be to have it on a separate piece of paper, not have it on the bottom half of one sheet and following over onto another that then continues with further pre-employment information, so that you can at least, in appearance as well as substance, say that it does consist of a separate document.
And now, the way the law is written, again, the law when it was amended in 1996, it became subject to many, questions and interpretations, because it was an enhancement of the original law that was originally passed in 1971 and implemented in 72, Fair Credit Reporting Act. So one of the things that the law says, you have to have the disclosure, and then you have to also obtain written authorization or consent. Federal Trade Commission attorneys who entertain questions from background screening companies, attorneys, general public when the law was passed originally in 96, felt that you could combine the two, the disclosure and the consent, into a single document, as long as it was a standalone document and there was nothing in there to detract from the intent of the law, which was basically to tell the candidate what you're planning on doing and why you're planning on doing it, meaning you want to run a background check and you're going to use it in connection with employment and what their rights are, and then getting the permission to do it. So there are companies today that do it both ways, but from the FTC attorney opinion letters, you could combine it. We use a combined disclosure and consent, but some companies will do it separately. They'll disclose on one page and have another page totally with an authorization or a consent. Either way you do it. But again, it should be consistent with those principles that are required. Most importantly, is not to include a release or waiver of liability in the document. It was something that was done, after the law was initially passed, where you'd say a release from liability, any and all parties in connection with my, background check. It's been frowned upon. It's been raised as an issue in some federal district court cases. In a couple of the cases, the court just kind of ruled and said it violates the principles of the Fair Credit Reporting Act to include a release or a waiver of liability because it's considered extraneous information. It's not what the law ever intended to do. So our recommendation for sure is not to have one in there. Okay.
And that release could be a release of liability for the Consumer Reporting Agency or a former employer or a neighbor who might provide some information should the applicant or employee feel the information was not correct or was damaging to them. I think that's a common statement that we've seen on a lot of employment documents. But what you're saying is if they're going to include some type of a waiver like that, it needs to be on a page other than the disclosure and consent form.
Correct. You just don't want to invalidate the disclosure and consent. You become a target of litigation if you do.
Okay. Thanks.
So certifying. So one of the other obligations is that you need to certify to the Consumer Reporting Agency that you have followed those steps that I mentioned in the previous slide. That the information that's being obtained will not be used in violation of any federal, state, or equal opportunity law or regulation, and that if any adverse action against the candidate is to be taken based on the content of that report, then a copy of the report and the summary of consumer rights will be provided to the consumer before taking the adverse action. Okay, so what does that mean? All right, so we sign somebody up. We have a standard form called certification and acknowledgement. And basically what that form does is that we're sending it to you, the client, and you're going to fill it out, and you're going to agree to what this slide contains here, that you're going to have a permissible purpose, what the previous slide mentioned also, that you're going to use a disclosure and consent, that you're going to provide to the candidate before that you request the report, and that if, based on the report, you decide that you don't want to hire the person, that before you do that, you're going to send them a pre-adverse action notice with a copy of the actual report, telling them that you haven't made a final decision, but you're potentially not going to, you may not move forward with them, and giving them the opportunity to dispute the report, and then a copy of the summary of consumer rights, which we, as the CRA, would be providing to you. It's prescribed by the Federal Fair Credit Reporting Act. It's a standard document. It's available through the Consumer Financial Protection Bureau now. And that certification is, number one, an obligation on our part that we did explain that to you, and two, you sign it and send it back to us. We keep it on file. You're certifying to us that you, in fact, will follow those rules. If I don't tell you about it, I'm subject to a fine under the Fair Credit Reporting Act. If you don't follow it, you're subject to issues with the Fair Credit Reporting Act. So again, it's important that certification exists, and that's an employer obligation. So, as I mentioned before you take the action, you have to provide a copy of the report to the candidate as well as a summary of rights, and you indicate you haven't made a final decision. And allowing the candidate at least 5 business days, the law is silent on the number of days between the pre-adverse action notice and the adverse action notice, but the Federal Trade Commission attorneys, when they were queried on that, they felt that 5 days was a reasonable period of time, 5 business days, to give the candidate an opportunity to dispute the information. If you don't hear from that person, you can send an adverse action notice. So the adverse action notice would basically say, hey, we sent you a notice saying we probably weren't going to offer you a position based on the report. We gave you a copy of your rights. We gave you time to make some disputes. We haven't heard from you. We made a final decision. We're not going to hire you. And that's the adverse action notice. That's the process. It's a 2-step process.
And Al, if the candidate objected to the information that the employer is planning on relying on to decline to proceed with their candidacy, it can't just be, that's not fair, or I don't think that's such a serious matter. It's got to be something that contradicts the accuracy or validity of the information?
Correct.
Is that correct?
So for example, we very rarely have disputes because the information we provide, is accurate. There's a couple occasions where the court was in error based on the information we provided, and when the candidate comes back and disputes the information, our obligation as a consumer reporting agency is to reinvestigate whatever it is they're disputing. So, for example, they're saying we had one case in Illinois where the person was convicted of a felony according to the court records. The employer, under compliance requirements, was not allowed to hire anyone with a felony conviction. So it was critical that this candidate have the correct information in the report. The candidate came forward and said that the case that he was involved in, the charge was reduced to a misdemeanor. It had to do with steroids. He was in possession of, and was charged with possession and sale of steroids. The court did reduce the charge, but the court record didn't reflect that. So in that particular case, our researcher actually is a former court supervisor in Cook County, which was a nice thing to do because he went in and basically saved the candidate from having to spend money with an attorney to get it corrected. He went back to the court and told them to correct the record. So we then reissued an updated report showing that the conviction was for a misdemeanor. So that's our requirement as a CRA in the reinvestigation process. We must update the report, send a copy to the candidate, and a copy to the client. For example, if there was no change and our information was accurate and we conducted a reinvestigation, we would send a report back to the client and back to the candidate indicating that they disputed, we reinvestigated, and there's no material change to the report. It says as is. What Mark was talking about, we very often get these kinds of calls. They disagree with the client's opinion. They want to use the information. They're not challenging the accuracy of the report. They're just saying, well, that's not fair. I don't like that. That's totally different. That's not a legitimate dispute. That could be a dissatisfaction with the client's decision not to hire, but that's totally up to the client and between the client and them, and it's got nothing to do with the FCRA.
And that then would leave the employer to rely on their own subjective judgment that the nature of the criminal history is serious enough in relation to the job the person is being considered for, and insufficient, for example, an insufficient amount of time has passed so that it's considered this is still recent activity in that person's life, and therefore they're not deemed suitable for the particular job.
Correct.
Okay.
All right. So what's important is that you have some sort of established policy and procedure. You should have a hiring policy that includes a complete background check process, so identifying what the components are. So again, you can, if you needed to, defend, what your approach is and show that there's a consistent approach based on that policy. The background check would also be consistent with regard to what searches you do for which jobs and what the adjudication process is. So it's the process, not necessarily the outcome, that's more concerning in having a policy and procedure established. Because you may have different outcomes in the adjudication for different candidates. Any lessons learned, should be included in future orientation and training. So any, learned from your past experience with it are always included in the future. So where do you start? And we talked about this before. Employment application is a business record. There may be some compliance requirements there. It's designed to meet your needs as the employer and ask specific questions like, for example, what month and year did you start the job, and what month and year did you leave the job? It doesn't leave like a resume, a vague, somebody could put down, 2001 to 2002. Well, that potentially could offer the opportunity for somebody to be covering a gap of employment where an application is going to ask for a month and a year. Usually requires, as I mentioned, more detailed responses. So we've talked about the sales tool before. Background screening pitfalls. Okay, so some companies say that they do backgrounds themselves. They might use a search engine, or they might provide government provided public records. There are pros, obviously. They're free and they're quick. The cons are the person that's looking at it may be misusing or misunderstanding a public record. So there may be some jurisdictions, for example, that will allow an ARD or a PTI or a PBJ. We'll explain what those are. In Connecticut, we have ARD, which is an accelerated rehabilitation disposition. While it's in process, it's going to be a public record. It's going to show up on a Connecticut court website as part of an ongoing process. In some cases, that record may be sealed on a Connecticut website. You may not be able to see the charges, but if you can, it may say ARD in process. There's no conviction there. The person's applied for a way not to have a conviction show up on their record. Some jurisdictions remove it totally after the ARD is complete. With the PTI, other jurisdictions refer to the same type of disposition as a pretrial intervention, similar to an ARD. In another jurisdiction like Florida or New Jersey, for example, they refer to as PTI. PBJ, probation before judgment, same kind of concept. So you have to be careful on using that information as to whether or not it's an actual conviction. The case that's been dismissed on nollie, meaning dismissed is out and out where the court dismisses the charges against the person. So whether they were arrested or not is irrelevant. You can't hold that information against them. And a nollie case means it's a Latin phrase. Basically, the prosecutor has determined that he or she doesn't want to continue with the prosecution. Again, that's one of the dangers of you trying to do yourself. Inconsistent approach. You may not be able to do the same type of searches for every candidate. A person may be from a jurisdiction that doesn't have publicly available court records. Again, the information is unverifiable, unreliable. Many cases, the court will have a disclaimer on their website telling you that the information is not to be treated as, accurate, that you have to get to the original source if you wanted to verify that information. And there's potential employer liability if you're using that information. And some of it may be prohibited by EEOC, like Mark mentioned before. If you just arbitrarily decide because someone's got an arrest and they have no conviction, that's what the EEOC would have a problem with. Okay.
So Al, the do-it-yourself approach, the company is not legally or technically subject to the Fair Credit Reporting Act procedures and standards, but nonetheless may be wading into some dangerous territory because they can't be reassured as to the depth or accuracy or completeness of the information.
Right, and plus if you go to a court website, then it's you, the employer, going directly, so FCRA doesn't apply, as Mark mentioned. But if you use a third-party source, like for example, some of you may see mugshots.com, there's a number of different variations of that source company that they've collected from the public website or public source records of the government entity information about an arrest, and they've created these mugshot profiles with the charges, the date of the arrest, where the person is booked. That information potentially could be very inaccurate because it may not be up to date. When the arrest took place, that may have been an accurate statement, but again, it's just an arrest. And the other issue is if you look into the mugshots.com, if someone's information appears on it and they want to get it removed, there's a process that it's a moneymaker really, is what it comes down to. If you click through and you read about how to get your stuff off of mugshots.com, if someone want to have something up there, you have to pay a fee. The company is offshore. They're not in the United States that's put that stuff up there. So again, that's an example of where you can cross the line and not be aware of it.
How about the sex offender registry? That's a state-sponsored website?
As long as you're getting it and you see that it's a state site that you're getting that information from, then you're okay to look at it. But you have to be careful, again, that it's not a third-party entity that's putting it up there. One of the best sources to go to is if you go to the FBI has a national sex offender registry, but it's more porting you to the correct state source of the information when you go to the FBI's website about sex offender registries. The link that you're given there will click you through to the state authorized website where that information is housed.
Okay.
My recommendation, the bottom line is don't do it yourself. So, internet-based background checks, they're cheap and they're quick. The cons, unverified, same thing. Some of them are data brokers who may not be compliant with FCRA. Some of the criminal record information that they may provide may not be able to be used in hiring decisions, and again, there's a potential employer liability. I'm just trying to jump ahead here. This is a company, I'm not talking about the problem with this company site at all. They offer a wide variety of searches, and they've been around for a while, but they at least show a disclaimer on their page which indicates that they're giving it public data and they're not a consumer reporting agency as defined by FCRA, and it should not be used in making decisions about employment, tenant screening, or any related purpose covered by the FCRA. So at least disclosing that up front. Some sites on the internet that offer internet backgrounds don't disclose it. Those are the ones that can get you in trouble. So here they're at least telling you that. And if you wanted to get an employment background, their links on their site will take you to another site that will be FCRA compliant. So they're doing it the right way, so to speak. Some FTC actions that have happened recently in June 2012. Spokio, I don't know if any of you have heard of Spokio, but there was an outfit, they were collecting a lot of social media data, trying to basically help employers, and that they marketed to employers or recruiters that you could, use their data source to learn about candidates, but they were not compliant with the Fair Credit Reporting Act. So they wound up having to pay $800,000. That's still litigation with the FTC. There's another mobile app maker that violated the FCRA, claiming that users of apps could gain access to hundreds of thousands of criminal records without following other requirements of the statute. They operated under different names. I didn't put a name here. The parent company name wouldn't mean anything to you. There's two parent company names that are involved in this. But if you went to the Google Apps or the Apple Store, you could find an app that would say, Alaska criminal conviction records, for example. And they had a whole bunch of them, a host of them. So that's what they were doing. They were selling for 99 cents mobile apps and encouraging people to buy them to check criminal records in certain states. It was not in compliance with FCRA. Hire Right, a well-known background company. In August 2012, they were to pay $2.6 million as a penalty for multiple violations of the FCRA. And mostly it was inaccurate information and improperly handling consumer disputes. So the two major things they were doing was they had mentioned, if you remember, I talked about that data source. If you do a national criminal data check or a national criminal scan, that information, that database has to be verified before you can give it back. In some cases, they were not doing that verification properly. They were sending back information that was old and outdated. Another violation was if the consumer disputed the information, that this consumer was not being handled properly in regards to the process that I told you that we must follow in terms of me investigating a disputed complaint. The Consumer Financial Protection Bureau is the new investigative and enforcement arm for the Federal Trade Commission. It was created a couple of years ago. They've taken on the role of doing a lot of this stuff in terms of violations of Fair Credit Reporting Act. So they just recently had one of their first cases that they've come forward with as the CFPB. That was October this year. They took action against two large employment background screening companies, General Information Services, or GIA, and its affiliate eBackgroundchecks.com, and ordered them to correct their practices in terms of reporting information about job candidates and the accuracy. They didn't have a process in place that ensured that the information was accurate, so they had to do that, and they also had to make sure that the information was accurate. So both the process and the actual reporting.
Al, to put it in perspective a little bit, $10.5 million, $2.5 million in fines or penalties and damages. How many individuals were these does this data relate to? Were these hundreds of individuals, thousands of individuals?
Yeah, I don't know the exact number, but I remember it was a time frame period of time. So there could have been thousands of individuals that were affected in this time frame.
Over an extended period.
Correct.
Mm-hmm.
So I don't remember the total number, but again, the fund was designed to capture. It's kind of like any, settlement like this. It's designed to capture any of the victims in this scenario. And so if you had a background check done by these folks between this time period and this time period, you may be eligible for some sort of compensation, and that's what this fund was designed to do. And the civil penalty, the $2.5 million, was a straight penalty assessed against the organizations that they had to pay, period. So the $10.5 million may not be used up totally, or it may be used totally. It may not even be considered enough, but they allowed them to put $10.5 million up and said, okay, this should take care of the people who are aggrieved in this situation.
And do those kinds of enforcement actions brought by the Consumer Financial Protection Bureau, do those drag in the clients of General Information Services background checks?
They could drag in the client in the sense that if the client in some way violated the process, the Fair Credit Reporting Act requirements, they could be. But most of the things that we've seen involving the actual client have to do with litigation that's brought against them in a class action suit, which we'll talk about in a few cases here coming up. But that's where the client gets affected. So as I mentioned, these are FCRA class actions. So this was an individual written versus closet made. And then there was Singleton versus Domino Pizza. Those are some significant cases in the last few years. That they were including the liability that I mentioned before, the liability waiver, and the courts found that it invalidated the FCRA disclosure, so they were kind of fighting in favor of the class of plaintiffs who said, hey, we didn't get a fair shake here, you shouldn't have included that, it invalidated disclosure and consent.
So they used an improper disclosure and consent form, and then as the prospective employer, they got targeted directly as a defendant in a legal action. Correct.
And so I don't even recall off the top of my head, I'm not even sure they reached an actual settlement amount here in these two cases, but either way, it's cost the client, in both cases, significant legal fees to defend themselves in these cases.
Well, as I've often said, case dismissed are two of the most expensive words a business will ever pay to hear.
That's correct. These are two class actions where there was settlements, Pitt versus Kmart. And this is for failing to follow adverse action requirements, meaning sending that pre-adverse notice and then the adverse notice. $3 million, that was the settlement in this case. And then Bell versus U.S. Express. This is individuals, again, class action cases. Settled for $2.75 million for failing to obtain authorization to make proper disclosures. And again, that disclosure and consent that we talked about. These folks weren't doing it. They were just running the background checks and then using the information to make the decisions. Bottom line, proceed with caution. Make sure you're doing what you're supposed to be doing. That's important. And I mentioned the pre-adverse and adverse two-step. I kind of went over this before, but it bears just repeating. You decide not to hire based on the background screening report, the pre-adverse action notice with a copy of the report, a copy of the rights, and then a waiting period for 5 days that I mentioned. You can wait longer if you want, but I would recommend a minimum of 5 business days. And then the adverse action notice. You can also do current employee background checks if you have regulatory compliance requirements, or if you have a corporate policy compliance, or if there's an investigation of criminal activity, sexual harassment complaint. And the FACTA amendment to the Fair Credit Reporting Act allows you to do these employee misconduct investigations without going back to the person and saying, we need a copy of a disclosure and consent before we can do our misconduct investigation. You don't have to inform them before the investigation on an existing employee. But you do have to comply with FCRA if you're going to take adverse action based on the findings of that investigation. So if you're going to terminate, then you have to give them a copy of the report, the adverse action notice, pre-adverse action notice before you make the termination, and then give them a chance to say, hey, that wasn't me, or an explanation, or dispute.
But an adverse action could also include a denial of a promotional opportunity.
Correct, same thing. If you can do, an existing employment application.
So for a current employee, unlike drug testing, which applicants it's easy to do, current employees, you've got to have reasonable suspicion or working in a safety-sensitive or high-risk position for random testing, DOT, CDL license holders, things like that. Background checks could be done periodically on employees simply to verify that employees are staying out of trouble. If the nature of their job involves access to financial information, credit.
So if you have a corporate policy, for example, that says that certain people are restricted from accessing certain information, and you want to make sure that they continue along that path. If you have your policies that says that you periodically check to make sure that the person hasn't been convicted of a crime, you can have those elements. But again, you have to have something to refer back to. It can't be just random is really what it comes down to. You can't just decide, oh, you know what, Jerry, I don't like that guy. I think we should do a background check on him. He's been here for a number of years, but I don't trust him.
There's got to be some relation to the job.
Correct. Or some complaint or a compliance requirement, or some summons to say, listen, this person's doing X.
And annual driving history checks would be okay for those driving your vehicles?
Sure. Again, that would be something that would make good business sense to do to ensure that you're not having a risk exposure. If they all of a sudden had some issue that you're not aware of, they've got a DUI conviction that just surfaced and you never became aware of it, and now they're driving your car.
Mm-hmm.
Or they have an excessive amount of speeding tickets in the last year and you don't know about it. Okay? Once you have this program up and running, audit is very important because you need to ensure that what you set in place is actually working and it's working the way you set it in place to work. That's it. So it's kind of, we feel it's very important. And very often we'll go in and we'll do an assessment for a company and we wind up, auditing a process and we find out that things aren't being done the way they thought they were being done and you have a breakdown, you have a gap, and that, again, presents potential liability to you.
Now, is your firm subject to any kind of outside audit activity?
Depending on, we certainly have to comply with FCRA. To my knowledge, they're not out, conducting audits at this point in time. But where we interact very often from an audit point of view is, for example, the work number for everyone is a company that does verification of prior employment on behalf of employers. There's about 4,800 plus companies that belong to the work number. So like most major companies, if you want us to do a verification on somebody that works for AT&T, for example, we're going to have to go to the work number to verify that. So we have an account with the work number. Periodically, they will send us audit requests, and they'll want copies of the disclosure and consent of a candidate that we previously had requested a verification on, and we have to provide that to them. Same thing with driving records. We're audited periodically by the vendor that we get our driving records through. They'll periodically say we need a disclosure and consent on this candidate. You ran a driver's license request on this date. So there are order requirements that we are required to, and if somebody did step forward from the FCRA or Consumer Financial Protection Bureau and said, hey, listen, we're doing an audit now, we want, and it's mostly random. They'll give you a handful of names, and they'll say we want copies of the disclosure and consent. But again, Consumer Financial Protection Bureau has not gone to that degree yet. They're not anything proactive. They're just doing investigations. They're not doing any kind of auditing. Okay?
Okay. Thank you.
So in summary, effective employee hiring program, screening program, is your first line of defense. And using a qualified professional investigative firm ensures a consistent, objective approach to every candidate background. That's the way, again, we follow the same rules for every background check that we do, whether it's a company that we do 1 or 2 for a month, or we do thousands in a month, or hundreds in a month. Just, you can rely on a consistency that we'll be able to provide for, as well as any other consumer reporting agency that follows the rules.
And I would just add to that a bit of a promotional comment, but we've worked with Al and Baker Street Associates for years. They do offer a discount to CBIA member companies, and whether it's Baker Street or some other provider of services in this area, what you want is a live body, real person that you can speak with, because a lot of the information that often arises from the background search may not be entirely comprehensible to the layperson. And Al and any other service that you may use should be able to deliver some detailed explanatory information about what it means so that you can put it into the proper perspective, translate the legalese into the real world context for making a decision about either hiring or furthering someone in a career path, things like that. So that's certainly something that Baker Street provides, and we should insist on from any provider with similar services. We've got a couple of questions on the board here. Let me just touch on that. Number one, will attendees receive a copy of the presentation? Yes, we will be sending out a link with the recording so that you can access that again, as well as the slides. One other question here. What's the frequency of actual inaccuracies as opposed to those who claim to have one listed against them? How often do challenges turn out to be inaccurate information? And it might differ between criminal or credit information or employment history, things like that.
Yeah, I would say for the criminal side, in our experience in almost 28 years, two, maybe three. One I mentioned, and then there were two others. One the person had an outstanding warrant. He happened to have a common name, and the date of birth matched. That's the only identifiers that we had to go with for further investigation. He wasn't even in the U.S. at that time. He had emigrated to the country subsequent to that again, so there was not a fault on our part or the court records part, but it was just one of those situations. And I forget the third one, but I mean, it's been 3 in 28 years that have really been accurate challenges.
And I would say in that regard, that relates to the accuracy of your investigative activity. If someone is using a search firm that's just capturing information from whatever source possible and not going the extra steps to verify the accuracy originally, there might be a higher level of inaccurate information generated.
Correct. And for example, in that warrant case, we went back to the court and said, do you have any other identifiers? Sometimes the court will have an address. Very rarely do they have Social Security number, even though people would think that that's a common identifier, but for arrest records it's not. Any known marks, tattoos, and we go back to the client and say, does this person present with this, height, weight? In that particular case, the court had very little information, and the information that they did from a physical description point of view was very generalized, so it didn't really help in the case to separate that candidate from, a potential person who was actively sought for the warrant.
How about in the credit or employment history area?
Again, the employment history, it varies. A lot of people embellish on their dates of employment, their position, their responsibility, so that tends to be a higher number, but that's something that's subject to the client's interpretation. Also, job titles vary in terms of what an employer might actually put on paper as the person's title or position, and what the person actually is doing in a job. They might be in a supervisory role, but maybe their title was lead. They don't have the title of supervisor, so some of it's semantics. So it's a higher percentage in one regard. Education is probably around 30%. We find fault with educational degrees, either their GPA, their actual degree in the field that they said they had it in, and whether or not they have a degree. So,
yeah. On that last point, what's been your experience with some of the diploma mills that are out there peddling all sorts of degrees? Pay you $50 and you've got a PhD.
Yeah, it's actually a little bit higher. It's about $300 for a PhD. But they're out there. We have established lists, and we have flags in our system to identify schools. We have a database of known schools. We do a lot of verifications. Most of them are through the National Student Clearinghouse. So an unrecognized school we've either had notes on before because we come in contact with them. Unfortunately, they're a dime a dozen. They're out there. People are offering to sell degrees. Occasionally we find schools that do offer an online degree. They have some form of accreditation, but the accreditation is not something that is recognized by the U.S. Department of Education or the particular state in question in many cases. But it's better than having no accreditation at all. So again, in that case, that's up to the client as to whether or not they're willing to accept that. But we will, if a person presents a degree, even if we know that it's a type of diploma mill, our first attempt will always be to verify that they actually have whatever they claim they have from the entity. The next step then will be to identify that it is not a recognized, it has not been, the degree wasn't issued by a recognized accrediting body. And then it's up to the client as to whether or not they accept that.
So there are some legitimate institutions or institutions offering legitimate degrees involving remote online learning, and you're able to distinguish between those from the diploma mills that just print out a piece of paper.
Right. The University of Phoenix would be an example. One of the ways to distinguish right off the bat, if they have a .edu as the URL name, the chances are they're a recognized body. If they don't, if they have a .org, a .com, a .net, then it's kind of questionable, and then you have to do further investigation.
Right. So it's all about how far you want to look. You get what you pay for and the time you invest in it. Okay. Those are all the questions I've got on the board. We ran a few minutes over. I apologize, but we did start a few minutes late, so I wanted to make sure we gave everyone a full hour on this. But I'm going to, unless you've got anything further to say, Al, anything else?
Thanks for your time. I appreciate it.
Okay. All right. I'll call it to an end now, and thank all the attendees for staying with us and your patience at the beginning. And stay in touch with either us at CBIA or feel free to contact Al and Baker Street directly at Baker Street Associates if you have any further questions. Other than that, step carefully out there, folks. Have a great holiday season, and stay in touch with us. We appreciate your involvement with CBIA. Take care and have a good holiday.